Hey yo, welcome back. Peace, family. Welcome to part two, day two of the Rico Stop Cop City trial. We're gonna be airing a little bit of it. Try to get it on fast forward because I still want to air the YNW Borderland. So let's get to it, family. Appreciate y'all being here. Hit the like, hit the subscribe, tap in, share with a friend. You already know what it do. Appreciate y'all, family. Let's go. The hell, Bobby? My bad, family. Let's go. There we go.
Welcome to Flesh of the God.
Well, isn't this a nice surprise?
There we go. We have Polly. Sure. But certainly not least, Mr. Alberto. They are all accounted for, Mr. Fowler. Okay. Parties ready to proceed?
Yes, Your Honor, stage ready.
Okay, I didn't see that. I don't see Mr. Dejan hiding behind the monitor over there. Okay, the next motion we have this is Mr. Carroll's motion to dismiss and quash indictment / plea abatement of indictment for lack of prosecutorial authority. A very interesting read. Mr. Schwartz?
Was it good, Judge?
It was a very interesting read.
Mr. Hall will find out. Mr. Hall, Mr. Finley said take credit for that. Mr. Hall will be argued.
Mr. Schwartz has the best ghostwriter around. Who do we have, sir?
Good morning, Judge Andrew Hall. I, along with Lee Finlayson, represent Tom Juergens. Mr. Francis Carroll, through his attorney, Mr. Michael Schwartz, has kindly agreed to allow me to present the argument with respect to this motion to the court.
And just to save you a little time, Mr. Hall, I have read the motion. I understand you're saying didn't get a letter from the governor, gang and domestic terrorism, legislature gave the AG authority to do so, did not do so in RICO, get rid of the judge.
Right.
Okay.
And so I guess to cut to the chase then, I mean, because
I'm a big fan of that.
I'm here in the morning and hear Your Honor quite clearly. So kind of fast forwarding, just to set things up, as Your Honor's already noted in reading the brief, under the Georgia Constitution, the district attorney is the constitutional officer who generally has authority to prosecute criminal cases in Superior Court. In contrast, under the Georgia Constitution, from our perspective, that's the important part of this, is the constitutional limitation. The Attorney General has limited constitutional authority to prosecute criminal cases. And there's 3 instances the Constitution contemplates: Supreme Court capital felonies, not applicable here, skip on by that. In all civil or criminal cases in any court required by the governor, as Your Honor has already noted. Well, I'm unaware of that existing. It certainly was not pled in the indictment, certainly not part of the record of this case. And then the last one is shall perform other duties as shall be required by law. Georgia Supreme Court has said is that as shall be required by law means as required by the Constitution or the statutes of Georgia. So, fast forwarding, the RICO statute does not grant the Attorney General concurrent jurisdiction. As Your Honor's noted already, some statutes do grant that authority. Domestic terrorism is an example, gang statutes an example, maybe other ones, I just use those as illustrative examples, but the RICO statute does not. Now, that's not the only way that the Attorney General can prosecute a case. It's what I would refer to as more colloquially as statutes of general or general statutes granting jurisdiction to the Attorney General. And those are mostly found in Title 45, 45, 15, and 3 and 6, and 18 and 10, and different ones along there. So most of those require the governor, again, in the constitutional limitation that all civil cases and criminal cases require the governor's authorization, and has expanded that in some ways. That's a lot of you under that last provision of the Constitution. And so in civil cases, the Attorney General enjoys a lot further latitude in representing the state in cases and pursuing civil cases. Criminal cases still largely limited by the governor's authorization, right? The one that I'm going to focus on, since we're jumping to the meat of at least what I believe is going to be the issue for the court to decide, is OCGA 45-15-10. Right? And that statute authorizes the Attorney General to prosecute a criminal case without the governor's authorization when the defendant violates a criminal statute. And this, in my, I respectfully submit, is the key language here, quote, while dealing with or for the state or any of its officials, employees, departments, et cetera, et cetera. What I submit to the court is the court's decision is going to turn on what does, quote, while dealing with or for the state mean. It's a specific criterion. The way I'm reading it, and the way I would ask the court to read it, is the defendant must be, quote unquote, dealing with or for the state when he or she violates that criminal statute. It does not, I submit to the court, simply mean relating to the state or pertaining to the state. The legislature could have said that. Much more of a term of art that they're using. So it's while dealing with or for the state, which means that the defendant could be either side on what appears to be some kind of relationship equation. The defendant could be dealing with the state and being on one side of that relationship, and the state or the state entity is on the other side of that relationship. And in the course of that dealing with the state, commits a criminal violation. That would authorize the Attorney General to get involved. But the or for can easily get skipped, but it's a complete phrase. It's dealing with or for. And the or for, I respectfully submit, means that the defendant could be dealing on behalf of the state. So in the relationship equation, the first one was defendant one side, state the other side. This one, defendant's over here dealing for the state in some kind of relationship equation. In that situation, the Attorney General can also get involved. It would suggest, I think, and strongly support that there's an ongoing relationship, and during that relationship is when the defendant violates the law. I'm going to pause. I'll tell you right now, if Your Honor, at the end of this, when we look at it, and you decide, no, this means relating to or pertaining to, right? Which is what I say it does not mean. Right? If that's all it means, then it's a much more broad, expansive jurisdiction for the Attorney General than we believe is supported by the statute. But that, to me, Your Honor, is fundamentally the issue that the court's going to have to decide. And we know from when interpreting a statute that the court will start with the plain meaning of words as they're commonly used and understood. So, in looking at Black's Law Dictionary, dealing means, and I quote, this is the 6th edition of Black's Law Dictionary, means transactions in the course of trade or business, close quote. According to Merriam-Webster, dealing means, quote, method of business, manner of conduct, and dealings in the plural means friendly or business interactions. All right, these definitions, both from Merriam-Webster, which is commonly recognized as an authoritative source for the English language, as well as Black's Dictionary, that again is commonly recognized by courts and jurists and lawyers as an authoritative source for interpreting meanings of words. None of it's definitive, because the Georgia courts have also said to take a look at it in this context, but certainly persuasive, I would submit. All those are consistent with the phrase dealing with or for the state contemplates some sort of business or transactional interaction between two persons or entities, and it's during the existence of those dealings the defendant violates criminal statute. It is not. I think this is important, that the dealing with or for the state is in and of itself a criminal act. Right? It presupposes that some kind of relationship exists in some form or fashion. Now, the legal research I've done, I don't know if I should say surprisingly or unsurprisingly, but it's neither here nor there, there's not cases that decide this issue that I have found. Right? There's not really much case law out there at all. Right, one case that I have brought to the court's attention in brief is Brown versus State, 177 Georgia App 284. Right, it's an example of an employee of the State Department of Labor who was prosecuted by the Attorney General for obtaining fraudulent payroll checks. That seems to be an example of someone dealing with the state, although as an employee, perhaps it was dealing for the state. The Court of Appeals does not address that language. Principally, the Court of Appeals does not address the language I submit, because the record in that case reflects that the governor had authorized the prosecution. And again, when the governor authorizes the prosecution, then there's no motion for this. This motion doesn't exist, right? Once the governor authorizes the prosecution properly, then the Attorney General is allowed to go forward. We're here because there is no governor authorization. And so now we're looking at the meaning of statutes, and really the one statute that may permit, or that I believe the state will argue permits it to proceed without governor authorization. We would submit it does not. Another case that's cited in the Brown case is Meredith versus State, 148 Georgia Appeals 853. It's another case, this one actually involves a private citizen, but it's another case in which the governor authorized the prosecution for the attorney general. So although dealing with this issue in some form or format, it doesn't deal with it does not address the specific language of the statute that we're looking at, because in both cases, the governor had authorized a prosecution. So in preparing for this hearing, I then started looking at some other statutes that may have similar language to see if I could find anything that may aid the court, may aid.
So I guess this is why they didn't do the ruling yesterday. They weren't done yet. Shoot, they still making arguments against what she said yesterday.
All of us in deciding how to look at this issue, right? And there's a couple cases I've come across that as an officer of the court, I want to bring to the court's attention. I'm not sure that either one of them provides us much in the way of dispositive information, but I think, Judge, in looking at this issue, if I know about the case and I think it pertains to it or relates to it, I need to let the court know about it. So one is Williams versus Bolton. It's a 1971 case.
Wasn't there a case, forgive me, I don't have people subbing in for me every motion. It was, I think it was a woman, I want to say it was out of Gwinnett. The Attorney General brought the action against her, and I think the court reasoned that because it involved a grant from, like a grant from the state with state money, that authorized, that was the dealing for or with the state.
So I'm going to do a little guessing here, but this may be the second case I was getting ready to tell Your Honor about, and that's a different Brown versus the state. That is at 268 Georgia Appeals 629. It is a Gwinnett County case, and it involved, in fact, a woman who was investigated by the Attorney General. She had been running a nonprofit and received a grant of $10,000 from the governor. So that's the second of the two cases. That's a different statute. So it's not 45-15-10. It's 45-15, 17, and 18.
That allowed them to investigate. Would he or she be interpreted?
Yes, Your Honor. Yes, Your Honor. But to me, it's a fair case to look at, and that's why I'm bringing it to the court's attention, although it looks like the court already knew about it, because it's within that same realm of statutes that deal with statutory authority of the Attorney General. So 45-15-18 has to do with the prosecution, and she challenged the case saying, well, they investigated me without receiving a governor's authorization. Now, before they indicted me, they got the governor's authorization, and so at that point, we're no longer dealing with a non-authorized case because the governor authorized it before the indictment, but after the investigation had already gone forward. And in that case, and this is what I want to bring to the court's attention specifically, and I have a copy of the case if Your Honor would like a copy. Okay. So in addressing that issue, it says Brown, and Brown in this case is a different Brown but the defendant, obviously, maintains that because the governor did not issue the directive in this case until shortly before she was indicted, the Attorney General's investigation was unauthorized. Right, and then it goes to OCGA. OCGA 45-15-17A authorizes the Attorney General to commence investigation into matters related to the state, and the investigation to Let's Act began with the governor's grant of $10,000 to that organization on September blah, 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 blah. Okay? And it says thereafter the Attorney General's investigation was permitted under this code section. Finally, we reject Brown's argument that the Attorney General should not have been allowed to prosecute the case as, and it cites the code section 45-15-3, subsection 3, provides that the Attorney General will represent the state in criminal actions when required to do so by the governor, which of course has been occurred in this case. And so it's a different statute, but it has similar language with respect to the investigation. It's dealing with an investigation, not a prosecution, but it has language dealing with in there. Now in that situation, Ms. Brown had some kind of transactional business relationship with the state. It's not clear from the facts of the case, but it appears that she had reached out and either applied for or sought or some way obtained a grant from the governor in the amount of $10,000. And the court, in fact, specifically said, I already reported this to the court, specifically said that the investigation began with the governor's grant of that money to that individual. And it appears, because it was a fraud prosecution, that there was some kind of fraudulent application or something in the inducement or somehow in obtaining that money, it was subject to a criminal violation. So that's the closest I have found. Again, different statute, but same kind of topic area, and therefore something I would like, the court should consider. Again, it doesn't really fit our facts for two major reasons. One, Ms. Brown has an ongoing relationship of some variety with the state, and during that relationship, is some kind of, is alleged to have committed a criminal violation. One. Two, different statute. And really, three, the prosecution was authorized by the governor. So I think what we're really looking for, and I've been unable to find, and I've certainly tried, Your Honor, is some case in which it's not authorized by the governor, and yet the state's allowed to proceed under a theory of just somehow relating to or pertaining to. And that case, as far as I'm aware,
right. Oh, I mean, I'll be frank about it. The police lie. They've lied, time and time again.
Does not exist. So again, our position is that the language dealing with or for the state, it has a specific meaning. It is not what I would refer to as language that you would normally use in a statute if you're trying to grant the Attorney General just general criminal jurisdiction anytime the state is an alleged victim of a crime. It has to do something more. It seems much more focused on entities or persons who are doing business with or somehow engaging with the state, and during the course of that relationship have committed or alleged to have committed some kind of criminal violation. Based on some arguments that the state raised at the Isla King matter, where I was not present, but my understanding of these arguments is that the state may try to argue, so I'll go ahead and address now in the interest of some brevity in moving this along, that the damage to the Georgia Public Safety Building, which happened back in July of 2020, qualifies as dealing with or for the state, such that that would subject that act to the jurisdiction of the Attorney General. I think the easiest answer and the most straightforward one is that those defendants who allegedly committed those acts were not dealing with or for the state. They had no ongoing relationship or business transaction with the state. That is a situation where the only interaction, as I understand from the allegations in the indictment, was the actual damage done to the Georgia Public Safety Building by those individuals or those defendants, allegedly, and there's no other kind of interaction or connection between the two. That would be much more if Your Honor were to rule against me and say, well, Mr. Hall, like the argument, but this is really, it really means relating to or pertaining to. That would fall much more into that category. It does not meet the statutory criteria of dealing with or for. Kind of as a side note, if Your Honor were to go down that pathway and decide, well, I think it's broader than what Hall is telling me here, or the way that Hall is reading it, I would note that the public safety building occurred in July of 2020. That was long, months and months and months before the Atlanta Public Training Center was ever announced. And so I think, as Your Honor had already noted yesterday during the demur arguments, it's really hard to imagine you can have a RICO conspiracy.
So yeah, this is about the Cop City. I'm sure most of y'all was here yesterday for some of the previews, but here's a little clip.
Protest what happened on Wednesday here, where they were handing out that vehicle still up in flames here over at Andrew Young and Peachtree. And if you take a look over here, if you pan over, I want to show you. This is what they were handing out at that protest. So it was a largely peaceful protest where they just wanted what they're calling justice for so sorry. And right now you'll see basically justice for so sorry. And right now, you'll see, basically, they want justice for him after the shooting that happened when the Atlanta police and the different law enforcement agencies were raiding the forest over there to try to basically clear out the forest after everything that was going on. We're all related to this. It was Entrenchment Creek Park. They're trying to clear the woods of activists camped out there protesting the site that they call Cop City. That's really what this was turning into. It was a calm, peaceful protest, but it does appear it started on
Conspiracy, which is defined as a legal conspiracy to prevent or stop or cease the operation or building of the Atlanta Police Training Center when it wasn't even in existence at that time. I think most of all, and then secondarily what I note is that if the Georgia Public Safety Building is the government's theory or the state's theory as to why it has, that act has invoked the limited jurisdiction of the Attorney General, then it should have been pled in the indictment. It's not pled in the indictment. We're left looking at an indictment that requires you to plead. And these are constitutional jurisdictional requirements. We know it's constitutional because the Attorney General has limited authority. And so if you're going to say that some event qualifies as dealing with or for the state, you must allege, I would submit, sufficient facts and otherwise alerted when this is your basis to invoke the jurisdiction under that statute.
Do you have any cases where it involved leaving it in the indictment?
No cases on point as to this statute. The ones that I would use by analogy, Your Honor, are cases involving venue. We may all know Atlanta Police Department generally, or Fulton County Police Department generally responds to cases in Fulton County. You've got to plead venue. It's not up for debate. Venue's not pled and proven. It's a defective indictment. It fails at trial. Another example would be statute of limitations. If there's an exception to the statute of limitations, then again, it has to be pled and if necessary proven at trial that the exception for the statute of limitations applies or the statute was told. So the answer to Your Honor's question is no, I don't have a specific example as to this statute of this invocation, but by analogy, there's other constitutional and statutory requirements where specific pleading is required in order to survive a challenge like this, a motion to dismiss or a plea in abeyance.
Well, you go back and, did that happen in the indictments in the Gwinnett Brown case?
I don't know the answer because I have not pulled the indictment. I don't know the answer. I also don't know whether that issue was raised, a failure to plead or not.
Well, it didn't appear that, I didn't see that in the opinion.
Yes.
But I also didn't see the charging document was not in, it didn't discuss whether or not it was pled. It just said there was a previous authorization from the governor.
Right.
Post-investigation or pre-indictment. Didn't say one way or the other whether it either A, was contained in the indictment, or B, needed to be contained in the indictment.
I certainly don't know the answer as to the former, as to whether it was in the indictment in the second Brown case, the Gwinnett County case that we were discussing. Okay?
Or any of them.
Well, all right, I'm going to add on to that just a little bit, Judge. In the first Brown case, and I'll get you the site right here, I'm sitting here, let me finish my thought.
177 Georgia Ave, 284.
Okay.
I think that's what you said.
Yeah, in that case, so our position is it needs to be pled or included as part of the indictment. In that case, though, the Court of Appeal noted simply that it had been somehow made part of the record. So certainly with respect to, was it some way, somehow, this is the governor's authorization. Our position is it needs to actually be pled or otherwise introduced into the record. The Brown case certainly does not say that it needed to be pled. They noted that that information had been included
What up, Ali? I see you. Appreciate you joining, family.
in the record. So, did I answer the court's question?
The answer is you don't know.
Correct. I don't know as to what happened in the Brown-Gwinnett case. As to the second one,
You don't know what those indictments say one way or the other.
Correct.
You
That's
don't know if
correct.
it was pled in the
Correct.
indictment.
that's right. The other thing that they may
Would
argue,
be curious to see.
yes, Your Honor. The other question, or another point that the state may raise is the Atlanta Police Training Center also somehow provided a general basis for the Attorney General's jurisdiction. Kind of the same response, Judge. There's no ongoing relationship between the defense and the state such that
The law doesn't say in Title 45 or where the state is the victim of the crime, is your argument?
correct. I'll also note that APPC, to use the Atlanta Police Training Center, is not a state entity, it's a municipal entity, and nothing in the indictment alleges otherwise, which again, I would submit is important if somehow they're claiming that something about the indictment allows them to invoke the jurisdiction over 45-15-10. It needs to either be pled in the indictment, is my position, or at a minimum under the Brown case that ends with page number 284, it must somehow be introduced into the record, at least with respect to the governor's authorization. And then the last point that they may make is that the Atlanta Solidarity Fund, or some variation thereof, was a 501c3 Georgia registered company corporation entity. And what I would say is that the mere existence of being a registered Georgia corporation does not authorize the Attorney General to exercise criminal jurisdiction over a company. In fact, if we stop and think about that, if that were true, then every single registered company in the state of Georgia could be prosecuted by the Attorney General's office, and I respectfully submit that there's no reading of 45-15-10 that would support such a broad expanse of the AG's limited constitutional jurisdiction. And again, as with the other points I made with the other one, which I understand Your Honor may or may not agree with, but let me go ahead and make the point, is that no allegation in indictment makes any reference to ASF being an entity or place that's dealing with or for the state, which I believe and submit as a necessary allegation. So those would be the points I would make. There's one, I think, additional point I'd like to make in wrapping up here, and it's more thinking broader about this case as well. So I would say that even if the court were to find that the damage to the Georgia Public Safety Building or the Atlanta Solidarity Fund somehow invoked the Attorney General's criminal jurisdiction, and to be super clear, I know Your Honor already gets this, as I say, being overly redundant, I guess, is we don't agree that it does. But if Your Honor finds differently, to rule differently on that, then we certainly don't think that the AG's limited authority permits it then, based on those discrete instances of jurisdictional authorization through a statute, to glom every other defendant you can think of into this prosecution using those limited charges. Basically, what I'm saying is there's no ancillary jurisdiction in RICO cases in this state. The Attorney General doesn't have ancillary jurisdiction. If we have any doubt about that, we can just look at the RICO statute itself. It does not grant the Attorney General concurrent jurisdiction. Could have. We know the legislation knows how to do that. It did not do that. And so for that reason, I would say that
Yet.
yes, yeah. That's all public policy matters. The general assembly may change something at some point. But as of right now, they don't have concurrent jurisdiction. And because of that, even if Your Honor were to rule against me on the limited basis of those different discrete events, that does not allow them to add in everyone else into this RICO theory. So under all those reasons, I respectfully ask that you dismiss count one of the indictment as to Mr. Carroll, Mr. Jurgens, and every other defendant in this case.
Just out of curiosity,
Yes,
count 2 is domestic terrorism.
yes.
In the code, it says AG has concurrent jurisdiction.
Yes.
What does that do with count 3? Arson. I believe it's arson, right? Does that affect count 3?
No. I would say two things. I didn't move on count 3, number one, but to the extent that they don't have a concurrent jurisdiction over arson, then yes, that would also go out the door.
Okay. All right, state's up.
Good morning, Judge Farmer. If I may begin by saying I'm appreciative.
Okay, here come the states. States up. What up, though, TSC? Happy Tuesday, family. Y'all show TSC some love, dropping some heart hand emojis, some coins in the chat. Appreciate you, family. Y'all showing some love. Appreciate the support as always. Definitely. Let's keep it rolling, family. Appreciate you.
Mr. Hall, my colleague on the other side, he covered a lot of the issues that I was going to go over too, and a lot of the things he said I think were pretty fair recitations of the current status of the law in the state of Georgia. So I'm appreciative of Mr. Hall covering a lot of the things that I took a look at as well. And let me start with this. I agree with him about domestic terrorism. We have obvious jurisdiction over domestic terrorism. But let's turn to 45-15-10, which is the, if you will, dealing with statute. And to read the full statute to the court, and I think the court may have it in front of it right now.
I do.
It is that the Attorney General is authorized to prosecute in the criminal courts of this state any official, person, firm, or corporation. So we identify who the accused will be right there at the beginning of the statute, which violates any criminal statute, which could be felony, misdemeanor, whatever that is, while dealing with.
Shout out to Atlanta Community Press Collective. They got the names popping up and all this. Hell no. John Fowler is talking. Speaking.
Or for the state or any official employee, department, agency, board, all of that sort of stuff. So what we have is we have an authorization of a defendant to be prosecuted, and then it lists anybody dealing with, and it's funny because Mr. Hall sort of followed the same logic that I did when looking up what dealing with means.
With or for.
Pardon me?
With or for.
With or for, correct, with or for. And you know, it's interesting because I found other definitions of dealing with as well, which is, quote, conduct in relation with others. That's dealing with as well. So for example, if there was an attorney that didn't like a judge, they may leave the courtroom and say, and someone sees them and says, what's going on? They say, I'm dealing with Judge Smith right now. That doesn't mean that you're conducting.
Oh, he like love. Look, he a Deputy Attorney General of the Prosecution Division.
You're conducting some sort of transaction with them. Or you say, you know, you don't look well, what's going on? I'm dealing with a sickness. There's all kinds of definitions. And the legislature did not give us any kind of guidance whatsoever. I looked for legislative history. I looked for all of that to figure out what they meant by that. There's nothing in the history or anything like that. So we have to take the common sense and the natural reading of it. And the natural reading of it in the state's position is that the natural reading of it is that when you're dealing with something or you're dealing with someone, you're dealing with whatever whatever relationship that you have. There are a lot of different relationships that there can be. Now, in that relationship, it is the state's position. I couldn't find a case law about this, but even if it was this way,
We get to be a case of first impression. Yay.
is that the state can't create the jurisdiction over the defendant. I believe that the defendant would have to invoke the state's jurisdiction. It must be a defendant's action.
Well, let's start with this. Do you have a governor's authorization?
No.
Okay.
No. And that's why the Brown case doesn't apply. I saw the Brown case as well, and oddly enough, later on, I'm going to talk about a different Brown versus the state, even though there were two other ones that. So I'm going to talk about a different Brown versus the state. But here we have multiple times when the defendants invoke the state's jurisdiction. On page 49 of the indictment, the very first overt act, if I can point the court to that, it talks about attacking Georgia State Patrol headquarters. And it says right there, Georgia State Patrol. It's the state of Georgia right there. Now, by doing that, they are dealing with them right there by attacking the headquarters. Now, and it does say as well, it says any department, Georgia State Patrol, agency, Georgia State Patrol, institution, Georgia State Patrol. And so at that point, they invoke that. I would note that council also brought up the Network for Strong Communities, also known as the Atlanta Solidarity Fund. You can kind of use them interchangeably, but that's a discussion for another day that takes a long time to talk about, sort of interplay there. But that they did register with the Secretary of State. And they did, and they invoked the state's jurisdiction there as well. Now, the question that I think that was kind of dancing around at Mr. Hall.
So everybody who registers, every business that registers with the state is submitting themselves to the criminal jurisdiction of the Attorney General?
Yes, because I think the question kind of dancing around there is how much do you have to kind of deal with the state to cross into that threshold, right? That's really what I think the court is getting at. Paul is kind of dancing around a little bit, which is, well, there's not that much here. But how much do you need?
Did that 501c3 ever receive state funds?
Not that I'm aware of, Your Honor. But you don't have to.
That would have brought us back to the second Brown case.
Pardon me?
That would have brought us to the second round case.
Well, I think it's a difference from the second round case. But
Did he forget that they here trying to get a RICO charge? Why they keep talking about what they don't have to do? We don't have to do this. We don't have to prove that. We don't have to do this. We don't have to do nothing. We just got to say RICO and then everybody go to jail. What the hell is that? The hell, Bobby?
I don't think that you need to receive funds to do so. All you have to do is deal with the state. And when you register with the state, when you're a 501c3, you have to send paperwork back and forth. You have to send them information, they send you information back. You have to pay a fee to the state to say, I want to become a corporation. And they send you paperwork back that says you are a
You
corporation.
don't want to become a corporation, you just don't want to pay taxes on the money. You don't want to be a 501c3. If people could do it without becoming a 501c3, they sure would.
And I completely agree with the court about that, but that's exactly how the state can assert its jurisdiction over it, right? If people can't do it, is it permits the state not just to regulate, but to assert its jurisdiction over that. I'll give the court a different example when it comes to the Secretary of State. The Attorney General is, for the most part, the lawyer for state agencies. And there are times when they're not, but again, separate issue. But we can represent members, we can represent the state or the Secretary of State's office in civil matters. And so what I'm saying there is this, that if that's true, let's say there's a civil matter that comes up with the Network for Strong Communities, where they're suing the Secretary of State. The Attorney General can represent the Secretary of State. Why is that? Because it's a state matter. Because it's a state matter is the
Well,
reason
the
why.
Constitution gives them the right to do civil stuff.
I agree.
We're not talking civil stuff. We had some analogies to civil cases yesterday. I don't know that those necessarily.
And trying to combine the civil with criminal law. Like, it's two different things. Y'all got them here on RICO. Criminal RICO. You're not trying to sue them for money. Why y'all keep bringing up this civil stuff?
Translate into the criminal arena.
Correct, I somewhat agree, it kind of depends on the situation. But point being though, that what is the threshold of dealing with the state?
So when you register with the Secretary of State, you are submitting yourself to the civil jurisdiction of the Attorney General. You bet, sure. The criminal jurisdiction, on the other hand, different kettle of fish.
It depends, I think, on if, I'm not going to say that if someone who is Saturday driving their personal car down the road, going to, I don't know, Five Guys Burgers and Fries, and commits a traffic infraction that has nothing to do with.
On a state road.
On a state road.
On a state road, not county highway, on a state road.
I'm not entirely sure at that point that you're necessarily dealing with the state.
You're driving on state property,
It's possible. I mean,
just like the Georgia State Patrol building is state property.
I agree with you about state property, but they also threw a Molotov cocktail into the building while there were people present. And so that's another thing that invokes the statute as well, is it talks about employees of the state as well, where there were people present inside the building that had to go to the hospital.
So you get in a traffic accident with a Georgia State Patrol vehicle on a state road.
I think that's a little bit closer at that point. I really do, because at that point, if you cause the accident, and again, the defendant would have to invoke, because if you were rear-ended by a state patrolman, then at that point, I don't know exactly what there's an open container in the person's vehicle. At that point, they haven't invoked that jurisdiction. But
You're speeding on a state highway and Georgia State Patrol pits you and you get charged with fleeing and attempting to.
I suppose it's possible, but at that point, I'm not sure you're actually invoking the dealing with the state by driving on their road, right? So, but here, they invoke by Secretary of State, by attacking the Department of Public Safety headquarters. And I know they talked about the Atlanta Public Safety Training Center just being for the state, or just for the city of Atlanta, but it's not. It actually trains state.
Judge, I apologize to my counsel, Mr. Fowler. I am a little worried we're getting into what came up yesterday about proffers and I'm objecting to. So I'm going to object to any proffers that are being offered for evidentiary reasons. My apologies to interrupt. I really hate interrupting counsel's argument. If he's just talking illustratively, it's one thing. If these are admitted as substantive evidence for the court to consider, I respectfully object to this.
Whether or not who owns the training center?
Yes, and what the funding is, none of that's in the indictment, none of that's in the record.
Whether or not it trains people is different than who owns it.
Right, as well as the people inside of the Georgia Public Safety, and we were starting to get all these extraneous facts. So I wouldn't even raise it yesterday.
I'm going to accept this proffer that inside the Georgia State Patrol building, there were Georgia State Patrol men and women.
Fine.
I'm going to accept this proffer on that one.
Yes, sir.
So I would also point out to the court another example on pages 99 and 100 of the indictment as well. It talks about different defendants who are engaging with an employee of the state government. That's Trooper Jonathan Salcido. And again, Trooper Salcido did not engage them. They went to his house in Bartow County. And so what we have there is, again, evidence of other defendants engaging state employees on their own. And so we're starting to see this constellation of these defendants engaging with the state again and again. And so what we also see is
Could you not have with the state, I mean, let's say the Attorney General wanted to help the trooper take out a TRO in a civil arena.
well, I don't think that, because that's not prosecuting, and this statute requires prosecuting the criminal courts. And so I don't think that the statute applies there, because like you said, that's civil. So I don't think you could do that.
You're subjecting yourself at the very least to a civil action brought by the Attorney General.
Potentially, I'm not entirely sure of our civil jurisdiction, I'll be honest with you, Judge. I would go to one of our civil lawyers. But I'm talking about criminal jurisdiction. And you're talking about a civil TRO. And so when we're talking about 45-15-10, and maybe I misunderstood the court's question, when we're talking about 45-15-10, we're talking about criminal prosecution.
Right.
And so by engaging with the state, engaging with state officials, engaging with state employees, engaging with state agencies.
What I'm saying is, I agree with you, you're subjecting yourself to the jurisdiction
Right.
in the civil arena, but are you in the criminal arena? Are you dealing with them to the extent that you are dealing with or for
Yes.
the state? Clearly you're not dealing for the state.
No, I don't think there's any instance where any defendant in this case dealt for the state.
So you're dealing with.
Yes.
So you want that with to mean pertaining to versus in some sort of contractual or business relationship, which was, I think, Mr. Hall's definitions from Blacks and Merriam-Webster's. Which dictionaries did you use?
You know, I wrote down Merriam-Webster. I'm not sure that I did use Merriam. I think it was just sort of and you can look it up.
I heard Judge say Blacks in there. Judge over there off the Black's Law Dictionary. That's what they supposed to be using. Talk about Webster. What the fuck you looking at Webster Dictionary for?
Now, I think that was just kind of a note to myself, like, hey, it was a dictionary. I may have used dictionary.com. I don't know which one that I used, but I can give the court the quote. But you asked about pertaining to. I think the closer one would be one that Mr. Hall used that I made a note on it. He said engaging with the state would be the closest one. And so engaging with the state is clearly what happened. They engaged with the state in various ways. And so the question
Engaging with is different. There was certainly
the dealing with? I think it would be closer than pertaining to. And I say that with respect to the court, disagreeing with the court.
Merriam-Webster. Dealing. Method of business.
Why are you not using Black's Law Dictionary? Because Merriam-Webster confuses people. Black's Law Dictionary speaks on actually what's going on, and they don't like to use that when they come from the state. But that's what they're supposed to be using. That's why it's called Black's Law Dictionary. It's about the law terms, not Merriam's terms.
Dealings, plural, friendly or business transactions. Let's see, also. There were reports of shady dealings between the two sides. It's a reputation for fair dealing.
So if I may, you can actually look up the term deal with as well as a phrasal verb on Merriam-Webster. The first definition is to be about something, to have something as a subject. And so I would respectfully suggest to the court that looking up for going to Merriam-Webster would be deal with as opposed to just the term deal. Because I think the term deal with is a term of art that is in 45-15-10. And the first there is to be about, to have something as a subject.
The OED makes you buy a subscription. And I do not have a subscription for the Oxford English Dictionary.
I do not either, Your Honor. But again, kind of going back to the notion of how much do you need, one thing I would suggest to the court is that in the indictment, we have multiple instances of what we title in our legally known as overt acts. And so I don't know, there is no case law that I can find on this as to what the standard for how much you need or how much you need to interact with the state. But I would suggest to the court that this is sufficient. An overt act, at least one overt act has to be conducted to engage with the state. Now, again, I don't have any case law to back that up. I also don't have any case law to say that is not enough. But there's more than one overt act in this indictment that suggested that these defendants interacted with the state. When we're looking at how much, though, how much do you have to interact with the state?
But it seemed like all the stuff they talking about, the overt acts, is all by other people, not the people that's in the courtroom. So how are y'all putting all them together is the thing. Like, why are y'all just trying to jam everybody into one bunch and charge 100 people for 10 different crimes? That's crazy.
I did kind of take a little bit of a broader survey of, like you said earlier, we don't like to compare it to civil, but I didn't know where else to look other than kind of those jurisdictional hooks. In the civil world, when you are trying to bring someone into a civil lawsuit, a single event is sufficient to impose jurisdiction over an out-of-state defendant. And that's McDonald versus Roy E. Beatty and Associates. It's 203, Georgia Appeals 807. Behar versus Aero Med International, 185, Georgia Appeals 845. In addition to invoke the jurisdiction of the Superior Court, all you need is a single felony. You don't need more than one. Here we have multiple overt acts. When we take a look at the federal criminal jurisdiction, all you have to do is you don't even need to make an overt act. All you have to do to invoke the federal criminal jurisdiction is cross state lines. That's all you got to do. You don't have to commit a crime. You don't even have to commit an overt act. All you got to do is cross state lines. And so when we take a look at that kind of that broader survey, I think what we see is it's a pretty low bar. When here what we have is we have the defendants affirmatively dealing with the state, affirmatively engaging with the state in every way, as not just alleged in the indictment, but also outside of the indictment as well. Now, one thing that I do want to address that I respectfully disagree with my colleague on the other side about is he indicated that it needed to be pled in the indictment. I respectfully disagree, and his examples were that you have to plead, you have to plead, and I believe the statute of limitations were the things that you had to plead. And the reason that you have to plead those in an indictment is because they're material elements of crimes. You have to prove venue, you have to prove the statute of limitations. Those are statutorily required as part of an indictment. This is not statutorily required as part of an indictment under the OCGA. Instead,
More analogous to a civil suit, jurisdiction pursuant to whatever statute or whatever code section, and then, or why you're in the Superior Court has jurisdiction for this because of X, Y, and Z, versus, your garden variety indictment doesn't say the attorney general or the district attorney has jurisdiction to do this because it says so in the Constitution.
correct. It doesn't say because there's a felony here, here's your act. I agree with the court about that. So the final thing that I will move to is I respectfully disagree with
But it does have to be somewhere in the record if there's a governor's authorization.
Yes, there does need to be, in some way, shape, or form, something about that, and that's why we're here today. The final thing is I would respectfully also disagree with my colleague on the other side about the remedy here. And so going back to the first Brown case that we talked about, that's the 177 Georgia Appeals 284. I agree that it doesn't apply insofar as to the analysis under 45-1510, because that involved a governor's appointment and all of that sort of stuff. There is one small area where I do think it is important, and that is the acknowledgement, because the case is almost 40 years old, is the acknowledgement that a plea and abatement is the proper vehicle for this motion. I agree about that, and that is alleged in this motion, but I'm getting somewhere with that, which is this. There's a set of, well, I know there was another Brown versus State that was discussed earlier. There's a third Brown versus State here. It's two.
All right, my bad. That might be me causing a little buffering. My bad. I was adjusting my thumbnail and it caused some issues. I'm gonna let it load up a little bit. Appreciate y'all being here. Hit that like, hit that subscribe. This one won't be too long.
Welcome to Flesh of the God.
Well, Isn't this a nice surprise?
295, Georgia 240. It's a Supreme Court case, and it talks about there are two kinds of pleas and abatement. And there's a proper effectum and there's proper defectum. There's two different kinds. And it was in the discussion of a grand jury presentment and whether a grand jury presentment should be quashed or whether it should continue going on with just the problematic part cutting.
Seem like it's still a little buffer. Okay, it's catching up now. It's catching up. Give me a few more seconds, family. I don't know. Yeah, sometimes it mess up when I go and mess with Photoshop. They don't communicate well, so I closed down Photoshop. We should be good to go. Appreciate y'all again. Let's go.
Cleavered off, if you will. And what it talked about, it kind of sounds exactly what it sounds like, which is effectum, does it affect the process, or defectum, is it a defect in the process? And there's a difference that results in the remedy. Proper effectum would be something akin to a grand juror that has a vested interest or an inappropriate interest in the grand jury proceedings. So in other words, that can't be fair and impartial. Proper defectum was when a grand juror was not statutorily authorized to be on the grand jury, such as someone who's not a United States citizen, doesn't live in the county, doesn't meet the age requirements, or something like that. In Brown, the Supreme Court said if it's a proper affectum issue involving whether someone can be fair and impartial, and I think the example that they used there was that a couple of the grand jurors were related to the victim or maybe the defendant, something like that. They said the entire thing has to go away because it was taken from the beginning. In the defectum area, which is I think more akin to what we have here, because if it's someone who shouldn't have been here, the answer is that in that case you have to clear that part off, and it just abates, and it's plea abatement. The indictment, it just stops until someone else takes over, which I believe the proper, if this court were to rule against this, which of course I don't concede, would be the district attorney's office. And so Bonnie Willis's office would take over and prosecute this case. I believe that under Brown versus the state.
Or Sherry Boston?
What'd he say about Fonnie Willis? Hold on. What'd he say about Fonnie Pack?
But she can't because someone else takes over, which I believe the proper, if this court were to rule against this, which of course I don't concede, would be the district attorney's office. And so Bonnie Willis's office would take over and prosecute this case. I believe that under Brown versus the state.
Oh, so they not prosecuting. He said if they don't prosecute it, then Fonnie Willis' office gonna take over and prosecute it anyway. Ignore.
Or Sherry Boston?
Well, she can't because she's not the district attorney of Fulton County. So of course, she could bring those charges in DeKalb County if she wanted to, whenever venue is over. She could do that if she wanted to. She has concurrent jurisdictional role.
We heard a lot about why there weren't certain counts because we didn't have venue yesterday. So, you know, Bonnie Willis has jurisdiction over the crimes that occurred in her, but you're gonna say she could take over the RICO? But did she just take over your indictment? Or did she start fresh?
Under the Brown case, I don't think the indictment is quashed.
Or do we cleave count 1 and count 3 and leave you with count 2?
I don't believe so, Your Honor. I don't, because that would be quashal of the counts, which is what Brown talks about is not appropriate under the defectum. It's proper under the affectum.
But if the Attorney General didn't have the authority to bring the indictment, doesn't that make the indictment a legal nullity from the get-go?
I don't believe that's what Brown stands for. And you know, I would point the court to another case, and I don't have the site off the top of my head. It's the Lample case, I believe about 16 years ago out of Clayton County, maybe 12 years ago out of Clayton County, where an individual testified before a special purpose grand jury. The trial court found that the testimony given by Mr. Lample in front of the special purpose grand jury was outside the scope of the grand jury. And when the Supreme Court ruled, they said, you're right. And as a result of his testimony, he was charged with perjury. And so the Supreme Court said, you're right. His testimony was outside the scope of the special purpose grand jury. And they said, you're right, that testimony should not have come before the special purpose grand jury because he couldn't have been there. But the answer that the Supreme Court gave was, but your remedy is not quashal of the count. The remedy was you continue on, and it's not a problem with the indictment. And so, yes, Your Honor, go ahead.
I'm reading your Brown case, the 295 Georgia 240.
Y'all stay tuned. After this, we're gonna get into that Y&W Bortland with the Y&W Melly trial. Should be starting around the time we finish this. I got the redirect set up. Appreciate y'all being
Part of
here.
their observations are dictum, so they're pontificating.
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop.
Well, isn't this a nice surprise?
So that case is about removing grand jurors.
Correct, it is.
So the analogy here would be removing the attorney general.
I think so. I mean,
But if you remove the attorney general and say he didn't have the authority to do what he did, I'm having a hard time saying, okay, he wasn't allowed to bring this in. But he did, so we're just gonna go with it. We're just gonna hand it off to somebody else. The constitutional officer for prosecuting here, the DA, who may or may not have brought that accusation to start with. So can the AG go in, bring an indictment, knowing he can't do it, I'm not accusing him of that.
no, I know that.
Knowing he can't do it, but forcing a case upon a district attorney? And therefore making the district attorney make some sort of political decision of whether I'm gonna take it and run with it, or do I turn around and look at the AG and go, I'm gonna not prosecute indictment.
But if I may just, I don't want, the word isn't take issue, but if I may just kind of
Discuss.
Discuss is a great word. One, I can't imagine, and certainly anybody I would.
I'm trying to ride the slippery slope both ways.
Sure, of course. Would take a case intentionally into grand jury and do that, just to pawn it off on somebody else. I can't imagine it.
Okay, but like I said,
Second.
that's all the way at the bottom on my slippery slope.
Right,
Okay.
right. I just, because of the way that it was worded, I just want to be sure that.
Let's say he accidentally did it. Well,
Sure.
dang it, I shouldn't have done this one. Here you are, madam or sir DA.
I think that's what Brown tells us. I really do, and I understand the court's logic. It's not as though I'm looking at the court thinking, how is the court getting there? What is he thinking? But I'm going by what the Georgia Supreme Court has told us is what I believe to be the appropriate thing. But all of that said, we don't need to get there because we have jurisdiction. These defendants have invoked the jurisdiction of the state, not just in the indictment, but also outside of the indictment, by engaging with the state. They've engaged with employees of the state. They've engaged with institutions of the state. They've engaged with agencies of the state. They have done that. They have dealt with every single one of those. And when you take, not just look at deal, but deal with, under Merriam-Webster, to be about something, to have something as a subject. And we talk about it in the indictment. We talk about, just the plain language of.
Okay, but dealing with usually implies, common meaning, a two-way relationship. There's a one-way relationship here, as alleged by the state. These folks did these things to the state, okay? There's no dealing with, it's doing to.
Well, I don't.
You're not dealing with, you're not looking for an exchange of ideas or an exchange of commerce or any kind of exchange. That was a one-way exchange.
Well, let me give the court the first example on Merriam-Webster of how they use it in an example. The one is to be about something or to have something as a subject. It says, here's the sentence. Her speech dealt with healthcare and the nation's economy. And so that's that they're not engaging necessarily there, but it is a single one-way street in the example that Merriam-Webster gives us, which is exactly what the court just said just a moment ago, is it's a one-way street. And so that one-way street, under the Merriam-Webster definition of deal with, actually is exactly what the court is talking about.
But if we take that definition, their act of throwing fire at the GSP building dealt with the state?
I mean, in a lot of ways, you know, judges, I
That
stand here. but
doesn't deal with the state.
I mean, in some ways, if you actually read the indictment and talk about anarchy and all of that sort of stuff, they are dealing with the state in the same way that if your kid makes you mad, and in some way, shape, or form, you say just colloquially, I'm gonna go deal with this. That's exactly what they're doing right there by dealing with the state. And so, yes, I mean, you know, we can talk about it in a number of different ways, but I think the plain language way that we talk about it under Merriam-Webster and without any further definition, that yes, this is exactly what this means. The plain language of the statute is exactly what it means. It can be one way, it can be two ways. It includes doing business. It does. If they had said, does business with, then I think we would probably have a completely different analysis here. But they didn't include that language. Instead, they chose the language deal with. Deal with, not do business
But
with.
you want the analogy to be any instance where the state is a victim of a crime. You would say any time the state is a victim of a crime, that's what your definition of dealing with is.
Yes.
But if you read it, and if it just said dealing with the state, maybe, but let's, dealing with or for.
Yes. If you shoot a state trooper, you bet.
Dealing with or, well, then you got a capital crime. Okay, and well, you're at least gonna get there in front of the Supreme Court, because the Constitution said so. But dealing with or for, I think both of you kind of focused on dealing with, but if we're dealing with or for, that is, isn't that more of a analogy to a business relationship?
No, I think what that does is it kind of flips around, you're dealing for the state, so at that point, it makes you an agent of the state. So for example, if I were to go out and commit a crime on behalf of the state in my job, I start, a little more difficult for me as a prosecutor, but if I was somebody who worked over in budgeting and had access to money, and I started doing some sort of illegal contracts and bid rigging with somebody, I'm dealing for the state, because then it would be a little bit more difficult to say you're dealing with the state as a state agency, or as a state agent. I think dealing for the state covers that, where state employees are doing something wrong as well. So that's what that is. And so, yes, if you, and when I said shoot a state trooper, I understand the court talks capital, that the court's aware trooper was shot in this case. He's survived. After multiple surgeries, he survived, because he's deceased now, but someone who was camping in the woods shot a state trooper. And so, yes, we are dealing with that as well. And so, when
Well, not in this indictment, we're not.
well, partially because Mr. Trot's dead, who shot the state trooper.
Okay.
But it will be relevant to, in case.
Well, I mean, under your theory of conspiracy, doesn't that make all 61 of them?
In theory. But it comes in any ways relevant to explain why some of these crimes were committed in response to it. But anyway, engaging with the state. If you shoot a state trooper, yes, you're dealing with the state. So long as he was within the course of his duties, all of that sort of stuff. Absolutely. You're dealing with the state. And I don't see how you wouldn't be dealing with a state official or a state employee, right? And I'll give the court another good example. Let's say that there is a traffic stop. You talked about transactions. There's a traffic stop and someone tries to pay off the state trooper. Might be a transaction there. Let's say the state trooper takes it. You able to prosecute that? Certainly. Because it was dealing with the state. And so it doesn't, and this is not limiting anybody to any kind of economic transaction. It doesn't limit anybody to any sort of business transaction, nothing like that. It simply says dealing with the state. And you know, the legislature meant what they said and said meant what they wrote and wrote what they meant. And here, that's what they wrote. They wrote dealing with the state. So if you are dealing with the state, and going back to kind of you don't have to have much at all. There's no standard here to say you have to have 2 overt acts, you have to have this, you have to have that. You only have to have a small hook. Just like if you're committing what would otherwise be a federal crime, and you drive all the way up to Trenton, Georgia, and then you step over into Tennessee, and then you come right back, suddenly you have invoked the federal jurisdiction by crossing state lines. You don't have to go 100 feet, miles, 6 miles, 12 miles. You only have to do it a little bit. Here, they did it, not just a little bit, they did it quite a bit. GSP headquarters, shooting a trooper Salcedo's house, as alleged on page 99, 100 of the indictment, and page 49 of the indictment. These defendants dealt with the state. That's what they chose to do. And when you deal with the state, you invoke the jurisdiction of the state.
Okay.
I apologize for interrupting the state earlier, but the state can talk the ears off the donkey. This continued filibustering has got to stop.
Bringing in the instance of primarily GSP headquarters, and I understand you have later on with Trooper, using that as the catch-all for all of these other folks. Same calculus, same argument?
Yeah, I mean, it's the same argument, right? It's a conspiracy, and it's the enterprise that it's engaging with. As part of it, they are conspirators, and that's the way it's alleged. As co-conspirators as part of the enterprise engaging with the state here. I mean, it's a pretty straightforward argument. I think I can expand on that. I know the court probably understands what I mean by that. But if you take a look, and I'll take a look at what page it is, and I was looking at it earlier. It's page 49. If I may just scroll.
The overt acts start on page 40.
Exactly where I'm headed, Judge. The defendants committed overt acts to affect the object of the conspiracy, which include acts of racketeering as described below, including all defendants. And those include all acts of racketeering, because when you're responsible for one, you're responsible for all. And so, for that reason, it includes all the defendants.
What? When you're responsible for one, you're responsible for them all. That's crazy. That RICO stuff is insane. You do one thing, like he said yesterday. So if I went and bought an ice cream, you saying that I'm part of the racketeering activity now. That's crazy.
And they did in multiple instances, and I think that's helpful. I mean, is it required? No, but I think it's helpful that they did in multiple instances engage the state themselves. Not the state engaging them, but they engaged the state on multiple instances. And so, I don't think it would work to say that, oh, there was only one incident where they accidentally engaged the state. I don't think that would survive, but I do think it's helpful for the state's argument to add on to say that they engaged the state multiple times. So there's no accident here. They intentionally engaged the state, they intentionally engaged state employees, institutions, agencies, all of that sort of stuff. All in the name of, as alleged, as part of the conspiracy, in the name of anarchy and all of that sort of stuff. And so they do engage the state for that reason. And so for those reasons, we would ask that the court deny the defendant's motion. I know I'm kind of wrapping it up right now. If we have any further questions, I'm not trying to avoid them, but happy to sit down if the court's finished.
No, I want to hear back from Mr. Hall. Thank you, Bill. Mr. Hall?
Yes, sir.
Are you not dealing with the state when you make the state a victim of a crime?
You are not, Judge, as that statute is used, and the state is not powerless in any of those situations. The easiest answer is the district attorney, constitutional criminal prosecutor for that county can prosecute, or you solve all these problems with the governor's authorization. In fact, every single example of the cases that both I, Mr. Fowler, criminal prosecutor for that county can prosecute, or you solve all these problems with the governor's authorization. In fact, every single example of the cases that both I, Mr. Fowler, on behalf of the Attorney General's office have brought to you involved exactly that. The governor stepped in and authorized it. So this is not a situation where, if Your Honor does not follow the state's reading, that while dealing with or for the state has to mean relating to or pertaining to, or the state is a victim, the state is something powerless to fight crime or combat injuries. They have all kinds of tools for that. You get the district attorney to prosecute it, you get the governor to authorize it. And every single example we've seen on the reported decisions, the governor in fact has authorized it. Not just involving state employees, including attorney general prosecutions against private individuals. So it's not like it's hard to do or difficult to do. It wasn't done in this case. So I would urge you to avoid taking the statute and expanding it beyond its plain meaning. On that note, I would say,
Well, I mean,
yes, sir.
dealing with has a much more, it has an expansive array of plain meanings.
So, yes, if you include the colloquialism deal with. I agree. If this phrase, and the phrase again, the complete phrase is while dealing with or for. And so, as Your Honor's already pointed out in talking with the state, and I'll just reemphasize this, that phrase has to be taken as a whole. You can't just take deal with and ignore the or for, because all part of how it's defined to give what's otherwise limited constitutional jurisdiction to the AG through a statute. But if you look at, if you just were to take the colloquialism, deal with, and you can say that all the time. I dealt with my child today. I played soccer and I dealt with a difficult attacker, defender, coach, whatever the case may be. We use deal with as a colloquialism in all kinds of ways. When it comes to a statute, I would respectfully submit, however, in the statute where it specifically says while dealing with or for, it has to have a much more narrow meaning and one more akin to the definitions I provided to the court from Merriam-Webster and Blacks, which it envisions some kind of ongoing relationship, a business relationship, a transactional relationship. I'm seeking funding from the governor to get some grant. I mean, on that note, you know, Georgia corporations are not generally subject to the Attorney General's criminal jurisdiction. Now, if that entity is engaging in some kind of business or some kind of ongoing transaction with the state, and while dealing with or for the state in that capacity commits a crime, that's a different proposition, but that's not what we're dealing with here. The mere status of being a corporation does not make you while dealing with or for. Your Honor asked briefly, I want to keep going, but I did not answer the court's question. I want to make sure I answered it.
You can keep going.
Okay. So the court had asked a question, well, I don't know if the court asked the question or it just came up in the discussions of the state about the civil jurisdiction versus the criminal jurisdiction. And that's addressed by the legislature in OCJ 4515.3. Specifically, the Attorney General has been granted the authority by the legislature to represent the state in all civil actions tried in any court, period. In contrast, that's subsection 6. In contrast, in that same statute, when dealing with criminal cases, it says when required to do so by the government to participate in, on behalf of the state, all criminal action in any court of competent jurisdiction. So it's a very different granting of power. I mean, in the absence of the governor's authorization, which is undisputed, does not exist here, we're left with 4515.10. And again, if deal with the colloquialism is what this means, then yes, it's much more of a relating to any time you even sneeze towards the state, it would probably qualify. That's not what the statute says. It's not a colloquial phrase. I think it's not a colloquial phrase for a few ways, we can look at that, but it specifically focuses on while dealing with, or as Your Honor's noted, or for. And it's not two different meanings, it's the same thing. And it has to mean, is too strong, but I certainly believe it means some kind of business or relational transaction relationship going on. The other point I'd like to make is...
Okay, from Mr. Fowler's point.
Yep.
Somebody shoots a state trooper, and it's not a capital.
Yep.
Okay?
Yep.
Can the Attorney General prosecute that individual?
Not under 4515.10. No, they cannot. It is not while dealing with or for the state. It is not. Can they prosecute them? DA can ask, Attorney General, we'd like you to come in. It happens all the time. Across all the counties in the state, it happens all the time. Metro counties, rural counties, governor can authorize them. They can come in that way. The Superior Court judge of that, Chief Judge can ask them to come in. There's multiple statutory vehicles to get the Attorney General in. But
Uh-oh, not the Superior Court Chief Judge. Y'all know who that is over here in this county, right?
I'm the gatekeeper.
That's right. He's still the Chief Judge.
the Attorney General, in that situation, in that hypothetical, where the Georgia State Patrol officer has been shot, not killed, and is alive, or subject to an aggravated assault.
So we don't bring the capital issue.
I'm just avoiding that based on the hypothetical, but yeah. There's no issue of capital, anything involved in it. The Attorney General cannot use 4515.10 and say, I'm just going to prosecute it. Lots of ways for the Attorney General to prosecute it, and certainly if they felt like the DA was not up to the task, lots of ways that they would prosecute it. But no, under 4515.10, that is not while dealing with or for the state. Otherwise, it would just be anytime relates to the state, or anytime you cause an injury to the state. And the legislature, we would say, generally knows what it means and means what it says. And so we would say, in that situation, if they wanted it to be broader, then they would have made broader language. And again, we start with the proposition that this all starts with a limited constitutional authority for the Attorney General. I mean, one way to solve all this is the Constitution could have given the Attorney General concurrent criminal jurisdiction as with district attorneys. It doesn't. General Assembly could have gone in, as they did with civil actions, and given concurrent jurisdiction with the Attorney General for district attorneys in all felonies, all misdemeanors, all criminal actions. They did. And so they certainly know how to do that when they want to give a broader expansion of jurisdiction. And we know that multiple ways, but one of the easiest ways is under 4515(3) subsection 6, where they give the Attorney General the jurisdiction to represent the state in all civil actions in any court. And that's the easy fix. And therefore we can say, because they didn't do that, they intended a more limited, much more limited grant of jurisdiction to deal with situations where someone's has some kind of ongoing business, transactional, whatever it is. I mean, charitable, transactional relationship with the state, and while that is ongoing, commits a criminal offense. And then at that point, the Attorney General can come in. It doesn't require the governor's involvement. That the General Assembly said, no, that's enough. We can just get the Attorney General in on its own initiative. Otherwise, the governor can always give authority for anything that he or she deems proper and appropriate. I would also say, Judge, that I do not agree with and would object and dispute this idea that jurisdiction in this case can be based on overt acts under RICO. So if the court were to find that the dealing with, while dealing with or for the state is more like pertaining to or relating to, and not what I'm asking the court to read it and as my reading of that statute, nonetheless, there's no, first I would ask the court not to find that, but if the court finds that no, it's more relating to or pertaining to, then that still doesn't allow them to bring those cases, that's jurisdiction over crimes, not over acts. And all that's been alleged in this indictment are a variety of over acts. And as we went through yesterday, some of them are crimes, some of them are not crimes, some of them are properly pled as crime, but I think none of them are properly pled as crimes because they don't have the elements. And
okay, you're loose.
Sorry.
Because if the Attorney General has the authority because somebody dealt with throwing a firebomb at a GSP.
Yes, sir.
Okay, so they now have jurisdiction over that. If that person is part of a conspiracy, you're saying the AG then doesn't get jurisdiction over the conspiracy, just over that one individual act?
Yeah, yes, if we're talking about the conspiracy, yes, assuming that we're past this whole while dealing with or for business, we're past that. You said no Hall, it's regarding or touching upon whatever.
Right. So if he's got jurisdiction as to one, does he not have jurisdiction as to all in the conspiracy?
Well, I would say the answer is no, okay, number one, because, excuse me, let me back up.
If the person who throws this thing is part of a corrupt organization.
Okay.
Okay. How does the Attorney General then not have jurisdiction over the other folks in that corrupt organization?
What I would say is that if you find if you find that with the dealing with or for.
Am I asking that right?
Yeah, you're asking it right. I'm not answering it right. You're asking it perfect. I understand your question. So in that situation, the bomb thrower would be subject to, or Molotov cocktail thrower, whatever you call it, would be subject to jurisdiction, given this way that we're talking about, hypothetically. And two, I would agree that people who are part of the conspiracy to throw that bomb, Molotov cocktail, whatever it is, would also be fair game because as co-conspirators of that act, they would be within the umbrella or ambit of that authority. I would not agree, however, that that would extend to include everyone in a RICO case, because in that situation, all we have is this ancillary jurisdiction that I'm objecting to, where they're saying, we have this act over here that gives us jurisdiction.
That is part of a broader conspiracy. So we're going to take jurisdiction over the whole conspiracy.
Yeah,
that's your argument.
Yeah, I would.
Mr. Fallon?
It is your, yes.
I would draw the line there. As to a traditional conspiracy, as to the act itself, yes. As to the fact that that act is pled as not even as a predicate, act in this case.
Well, we don't know, do we?
We don't know, right? But let's assume hypothetically, it was properly, to get to what I think the court's asking, if it had been properly pled as a predicate act, then yes, I would say that that would not extend to the
To
entire.
the other overt acts?
That's correct. That's why I would draw the
You
line.
only get parts of the conspiracy that, where the state is the victim?
Correct, yes.
Hmm.
I understand you may not agree, but otherwise what you're doing is allowing them to just say, we have one thing over here in July 5, 2020, the Georgia Public Safety Building incident.
The
And we're
members of this conspiracy, by committing an overt act against the state, have given the state, the Attorney General, jurisdiction over the whole conspiracy.
Okay.
I think you're in an all or nothing situation.
Okay.
Yeah, I don't follow you on that.
Fair enough. I appreciate your candor to me. That's fine. I'm going to move on that point. And
Okay.
I just respectfully, I draw the line there. I understand you disagree with my point.
You disagree with me, I get it.
Yes, sir. There's a comment that was made about whether there should be pled in the indictment the Attorney General's,
How they came to have jurisdiction.
yes. And I don't have a case on that point. I would say, though, that in the example that I believe the state gave, and I may be mismatching, maybe Your Honor, whoever gave the example of a traditional indictment with the district attorney involved.
That was me.
Yes, sir. So, of course, the district attorney has general constitutional authority, so it's not an issue, right? The only reason this would even be an issue with respect to pleading is that there's a limited jurisdiction for the Attorney General, and it's a constitutional limitation. And so when you're saying that my constitutional limitation doesn't apply, then I would say, Your Honor, respectfully, it has to be pled in the indictment in some form or fashion.
So you're saying that Gwinnett indictment, after the investigation, where there was a governor's authorization, that indictment would have had to have said, the Attorney General is bringing this action pursuant to authorization from the governor.
Yes. I don't know if it did. I don't think it was raised. I can't tell you what it says because we discussed, I don't know what it says. But yeah, my position would be, if you're trying to expand your constitutional limitation on jurisdiction, we can't just assume because you've shown with an indictment, it's okay. It's got to be pled, no different than venue or statute of limitations or anything else. Not true for the district attorney because they have a general criminal jurisdiction.
But you have no law or case law to back that up.
Zero. It's by analogy only, Your Honor.
I think as long as they can show it so that it survives the challenge, that's, I'm not convinced as of yet that it has to be pled in the indictment.
Yes, sir.
I would be curious to see a couple of those indictments. I think we all are a little curious now.
Right.
To see, was that even done? Because if it wasn't, and it wasn't raised, then you are the first brilliant man thinking this. Because the other folks missed that issue entirely.
It wasn't even my idea. I'm just, managing.
You're the bad man.
Idea, so I'm just one showing up with the argument. And then the last point I wanted to address, and then I'm again happy to answer any questions the court may have, nor do I want to overstay my stay, which I feel like I've already done. But let me just end on this.
I'm here every day, Monday
Yes, Your
through
Honor.
Friday.
Yes, sir. I do not agree. I do not agree that a plea and abatement motion to dismiss which we have filed, that the remedy, if Your Honor were to agree with us, is to keep the indictment active and bring in the district attorney for Fulton County. The analogy, to use the Brown case that Mr. Fowler cited, I believe would be that if it's an analogy I would use is we were challenging the AG's office for bias. First of all, I think that the Brown case deals with grand jurors and the constituency of the grand jurors. We're dealing with the constitutional authority of a prosecutor.
We're dealing with the charging document that came out of that.
Yes, apples and oranges, okay?
Who was allowed to be in the room? Who was, yeah.
Okay. But even secondarily, if we were challenging the Attorney General for bias, that might arguably be more of a effectum, or whatever the right word is. But this is one where the AG lacks constitutional authority, and that's clearly much more akin to a defectum, which the remedy would be dismissal of the indictment. John has already noted
All right, we pretty much got that. They about to go to break. I'm gonna skip forward to the end so we can see if the judge finally ruled. Like, geez, okay, it looked like he talking at the end. Hopefully he gonna rule. So I'm gonna skip forward to that. In the meantime, y'all hit that like button, hit that subscribe. Let's keep it going. Oops, my bad. Wrong one.
I do not find the attorney. At this time, I do not find the Attorney General to have the authority to bring this RICO case. The legislature can fix that. They did with gangs. They did with domestic terrorism. To bring this RICO. At this time, I do not find the Attorney General to have the authority to bring this RICO case. The legislature can fix that. They did with gangs. They did with domestic terrorism. I think it would be logical for them to do so with RICO, given that RICO, corrupt organizations, rarely stay in one jurisdiction. As this case, they cross jurisdictional lines. The Attorney General has constitutional duties, has statutory duties. And I think it would have been real easy to just ask the governor, let me do this, give me a letter. The mechanisms were in place, and the steps just weren't followed. It's not that he couldn't have gotten that letter. There are mechanisms in place whereby he could have brought this. Now we have the question of count 2. There's no question he had the authority to bring it. I think the defense even concedes that in their brief. So, the remedy, and I'm going to chew on this, I'm going to adjourn for the day, because I need to figure out where I'm going with this, is the remedy, does the whole indictment die? Or just counts 1 and 3, and we proceed with an indictment that has count 2 on it, and we go from 61 defendants to, is it 5? I have no question that the state is going to appeal me. And I may be wrong. The folks across the street will tell me if I'm wrong. This is, and I welcome their opinion. If I'm wrong, we come back down and we keep on going. But that's where I'm at right now. And I don't see, I don't even get to, given the fact that I don't find he had the authority in this particular instance, not that he can't bring a RICO charge, he just didn't do it correctly in this instance. I gotta go figure out what I'm right now. What would be the state's, you're going to want, even if we go forward on count 2, you're still going to want to appeal this. Obviously, to the extent that you need a certificate of immediate review, I obviously will write you one. I don't think redaction is, I don't know if it kills the whole indictment, because he had the authority to go in there and bring count 2. So, do we redact it? Then where are we with, do we now have 56 unindicted co-conspirators in 225 overt acts? As to, Because all those overt acts are part of count one. So they go away. Do we just go with the 5 defendants? Mr. Fowler, you clearly got something on your mind.
I do, because I had already thought about what happens if this does happen. You know, as a lawyer, you have to do that. I mean, with all due respect, we disagree with the court.
He already knew it was coming. We already planned for it. We already knew we was on some bullshit.
I didn't expect you to agree with me.
Right, and the court knows I've known this court for a long time. We respectfully disagree. We believe that the court's analysis is wholly incorrect.
Flawed.
Wholly flawed as well. But I think that if a certificate is granted on this, which I do think a certificate has to be granted because it's not a final order.
I mean, can I throw out the whole
monkey shit?
You know, the entire indictment?
I don't think so.
Well, if I throw out the entire indictment, then it is a final order. And
Correct.
you bring it up and they can tell me, hey, farmer, you got it wrong. You should have gone forward on count 2.
Correct. I agree. If you quash the whole thing, yes, that's a final order, no doubt about that. But if it's just count 1, I think at that point we have to have a certificate of immediate review from the court, in which case would of course deprive the trial court of jurisdiction, I believe, over the entire indictment. I don't think you can cleave off one, send it up, and then handle the other one. Correct. We've got double jeopardy issues.
Right. Well, and if I just go forward with count 2, I don't even get, you know, I'm not going to rule on the demur issues, given that I found he didn't have the authority to bring it. Because if it's a, you know, in my mind, it's a legal nullity because it never existed, so I don't have to, you know, if they send it back down and say you got it wrong, and I've got it, then I have to look at, okay, now I've got a valid indictment as far as these 2 counts are concerned, then I have to address the special demur issues. So I don't know that I'm not going to write anything on that because it's not right, given my ruling on the abatement. So we're done for the day, folks.
And so, will the court sua sponte issue if I presume for a moment that the court only limits it to count 1, will the court sua sponte issue the
certificate?
Thank you, I was blanking. Or does the court need us to move to 1?
I'll grant you one. For the record, the court is going to grant a certificate of immediate review to the extent that it is necessary for the state.
Okay.
Shout out to Flesh of the Gods. Tell everybody. Well, I still fighting through the devils, man. Like they be trying their best to hold me back, but y'all got to give the people what they want, bro. You know what I mean? The people want some real, man. It's time for the real people who ain't pretending to be in position. Shout out to Flesh of the Gods. Tell everybody.
Welcome to Flesh of the God.
Well, isn't this a nice surprise?
Well, all right. Shout out to everybody coming through. We still going, so don't leave, family. We gonna redirect to the next stream where we'll be covering the YNW Melly / YNW Bortland preliminary hearing. I mean, another pre-trial hearing. Yeah. So shout out to everybody in the chat. Ali, what up, though? I see you. Appreciate you, family. Keisha E, what up, though? I see you. No One, what up, though? I see you. Chad My Black is golden. What up, though? I see you. Appreciate you. Shout out to our stream sponsor, TSC. Appreciate you. And Chad My Black is golden.
The absence of evidence is not the evidence of absence.
Our stream sponsors of the day. And so, yeah, y'all stay right here. I'm going to go ahead and end this one. I'm going to switch over, get everything set up, and we'll be starting the next one at in 5 minutes or so. Probably even less. Maybe even less, family. So y'all stay here. Appreciate you. Hit that like button. Hit that share button. Appreciate y'all hanging out with your boy. And, yeah, we going to get it. Let me throw this outro on, switch the stream over, and I'll see y'all over there. Stay tuned, family.